decide the matter based on the oral and documentary evidence before you, at that stage you can consider. But
all right, let's hear the other side, because we got the point.
just-
You're you
Can
formulated the point now.
some 4 or 5 parts of your lordship's judgment. Now, this is one point. The second point, why the survey can't be ordered. In the suit, my lords, of 1991, an identical prayer was made.
Yes.
The prayer was made. An ASI survey was thereafter ordered. And ultimately, my lords, the High Court, by an interlocutory order, stayed that ASI proceeding by an order dated 9th September 2021, which is at page 37 of your lordship's paper book.
Oh, there's a second point.
That's the second point. So when, my lords, the High Court, in one proceeding, in relation to the same property,
We got the point.
has
Yes.
already done. That's the second
point.
Third point.
Yes.
A similar issue, my lords, has arisen and is pending before your lordships in the other SLP relating to the fountain area.
SLP number?
11351 of 2023. Undoubtedly, my lords, the Solicitor General on that day did orally tell your lordship that he was concerned about carbon dating, damage to the structure, etc. But the application was for a scientific survey.
Fair enough. There's a third point.
The order was for a scientific
Got it,
survey.
yes.
Your lordship says.
Mr. Ramadi, you made your point. What is the fourth point?
Yeah. The fourth point is, my lords, your lordship's judgment, my lords, in Aslam Bhure, 1994 2 SCC, page 48.
1992?
1994 2 SCC, page 48.
Yes.
Where your lordships directed that there was a threat to this particular property also. And for that reason, there was an order passed that status quo must be maintained. And the last point is, my lords, that Order 26, Rule 9, 9A and Rule 10 do suggest that these orders can be passed at any stage. Yes. But ordinarily, an order directing commission to have a scientific survey would not be appropriate before such time that the court is cognizant of the issues that arise. It is only at that stage that the court can direct the recording or scientific evidence which is specifically in relation to a particular
Let's
issue.
hear the response. You made your 5 points.
Can I just
Yeah.
cite this judgment?
No, you've already formulated the point. You've made your point on
I
that.
just want to cite certain passages.
You'll take it. Just give us the paragraphs.
Yes, if I may just read them.
No, we don't want to keep on reading now. Please give us the paragraphs, Mr. Ramadi. We are aware of the, we read the papers at home and we are at the preliminary stage today. Yes, what paragraphs?
Paragraph, my lords, from page 247 to 253, 661 and 732.
All right. Yes, Mr. Solicitor, what do you have to say? Well, or Ms. Diwan, who wants to argue first?
There is also, my lords, one other apprehension.
Yes.
My learned friend appears for the state of UP. Something very unfortunate happened, my lords, 3 days before.
What happened?
When the matter was pending and was yet being heard, there was a statement which was made by the Chief Minister of UP while the matter was hotly sub judice. There was a statement made, and if I may just read out that statement to your lordship. I don't want to, my lords, unnecessarily sensationalize, but it's unfortunate when the matter was hotly sub judice. Your lordship may just read the statement. Yes, read.
Come on, we did not. I don't know. He says that Gyanvapi is This, no, we also in argument say that according to them, the fountain, according to one side, the.
You are the state, you are supposed to be non-partisan in the suit. You are supposed to be non-partisan in the suit. And this was while, this is while the appeal was being heard by their lordship. This is also there.
Miss Diwan, would you like to argue first?
Just Lord, few points. First of all, my lord, this order under Order 26, my lords, it is really for the benefit of the court. This is an issue, my lords, of domain expertise, which the court, in its discretion, in order to aid itself in coming to a just conclusion, would exercise. And my lords, it is not in any manner prejudicial because one, my lords, apart from the non-invasive, etc., but it is not determinative in any manner. It is not, my lord, adversarial in any matter because it can go either way. And my lords, therefore, both parties, it's a chance, my lords, we are also taking, but in the opinion of the court, my lords, it feels that it requires that scientific investigation, that domain expertise, which it may not be equipped to do itself. And therefore, my lords, in its discretion, it has directed a survey. Now, my lords, it would amount to, in our respectful submission, a disablement in that sense of the court to, my lords, indict a survey. And, my lords, insofar as the rights of both parties are concerned, because we do not know at this stage what the survey is going to show, my lords, we have the right to file objections. And your lordships have also said that in the Ayodhya judgment at 654, that it's not just objections, even, my lord, there will be a chance to cross-examine. So nothing is closed at this juncture. It is not determinative in any manner. It does not prejudice anybody's rights. And my lords, I understand my instructions are that as the survey has progressed this morning, my lords, their representatives have been present. So, my lords, we would encourage, my lord, full transparency. If it is to be live streamed to the court, whatever it be, my lord, we have no objection to that at all. So, my lords, that is one. Secondly, my lords, insofar as, my lords, this issue about being barred by the Act, 91 Act, my lord, it begs the question. Because, my lord, the issue is, what is the religious character of this place? We have pleaded squarely, my lords, in our plaint at paragraphs, my lord, 42, 43, and, my lords, in other places as well, that there has been continuity of worship for a long, long time on a daily basis. And then, my lord, that was stopped in the year 1993. But we have pleaded, my lord, both, my lord, before 1947 and after. In addition to that, my lords, we have also sought, my lords, in respect of the right to worship, my lords, both what are known as visible and invisible deities, the invisible meaning that they may be submerged. So my lords, we have made these pleadings. Now, in the Order 7, Rule 11, my lords, instead of, my lord, ultimately the fundamental principle is you only look at the plaint. You do not go to the defense in any manner. But, my lord, they tried to bring in their defense, unsuccessfully so far. But, my lords, what they say, and this is what was said even in the order which has been passed yesterday by the learned Chief Justice, that they argue that this is our imagination, that they are deities over here, etc. So if this is our imagination, my lords, on the one hand, then our hands are in every way tied that even the survey cannot take place. So it can't be both ways. There has to be a survey because that will make everything clear. So surely they cannot damage. They know better. They should know better. And my lords, this issue, it goes to the root of the matter, the religious character. It cannot be barred at this stage because this is the issue, my lords. Ultimately, what is it? Whether it is, my lords, if there is worship after that cut-off date, then, my lords, the religious character, the continuity of whether it's the worship, whether the, my lord, because the Advocate Commissioner's report, of course, my lord, they have participated in it. The SLP is still pending, but they have participated in that entire process. They have attended it. So, my lords, they attend it. There have certain signs and symbols clearly have been seen over there. And then, my lords, it's only logical that they should be taken to its logical conclusion by a scientific survey. So, my lord, that is in most respectfully, my lords, our submission on this.
Mr. Solicitor, oh, sorry, just 1 second, Mr. We'll hear you at the end. One more person on stage. Who's R1? And who is Ms. Diwan appearing for?
I'm sorry, my lord.
Ms. Diwan,
No, I'm for 2 to 5. This was actually our application for the ASI survey.
you are another plaintiff.
No, in the same plaintiff, Lord.
Another plaintiff.
Another plaintiff.
On the same,
One-
On the same.
same,
One-
then we don't have to have another argument there.
Orders of your lordship, in the SLP, which is already pending. And at page only, I will give the page number.
No, just formulate it in 1 second. Ms. Diwan has already argued. Why should you have another?
I'll talk.
Mr. Solicitor?
And nothing further to add so far as the implicit dispute is concerned, will scrupulously comply with what was undertaken before the High Court on affidavit. And do accordingly.
Anything else, Mr.
It should not prejudice either side, but not help anything.
Two aspects, my lord, which I want to urge.
Yes, Mr. Ahmed.
I'm sorry, Mr. Ahmadi, just a minute. My lord, I did not respond on that insofar as the other suit of 1991 is concerned. I just want to make a clarification there that, my lords, that was a very different situation. One, my lords, that was a title suit. Of course, my lords, on facts, it's a little different. One is with a title suit. Second, my lords, the 711 in that case had been filed and allowed immediately. There, my lords, the plaintiff had filed a first appeal before the district judge. That appeal was allowed, and that appeal was allowed, my lord, in the plaintiff's favor. The defendants filed, my lord, a 227, and there a stay was actually granted.
So, there what happened? The 711 was allowed.
The 711 was allowed in that case, my lord, by the learned civil judge, my lord, it was senior division. And then, my lords, it went up in appeal.
First appeal set aside the order.
Yes, it set aside the order in 1998, my lords. Then, my lords, the original defendants filed a 227 before the High Court, and a stay was granted of that suit. Now, my lords, while this stay was granted, there was an application filed for ASI, an ASI survey. And this was, my lords, in the year 2019. It was allowed by the learned district judge. I'm sorry, the civil judge, senior division. My lords, following the judgment in Asia surfacing, by presuming that, my lords, the injunction had...
So in that case, really the trial court had rejected the plaint and order 711.
Number one, reject.
First appeal restored the...
Yes, yes.
The district judge set aside the order. High Court therefore had to decide it, and it stayed the operation of the, stayed the suit.
In the meantime, my lords,
An application
the
was served.
court said that it's already expired and proceeded to grant the application.
Oh, I see.
So, my lord, that's the difference. In our case, 711 has been allowed and there's no such stay.
Oh, I see. Yes, Mr. Ahmed.
The distinction, my lords, in my respectful submission, is not clear for the
Yes.
simple reason that the issue before the High Court
Yes.
was squarely with regard to whether you should have an ASI survey. And that is, my lords, that particular direction of the trial court in respect of the same property stood still. Now, look, do I address your lordship on the order 7 rule 11? I take it your lordships are issuing notice.
On order 7 and rule 11, we'll today not take it up presently.
Your
We will hear this.
Your lordships indicated that your lordship.
We can do one of two things. Mr. Solicitor, Ms. Diwan, should we issue notice on that and hear that separate and dispose it off if you want to file a. So that then they can take a copy. Yes, they can.
They can accept notice.
We are on caveats.
So therefore, they'll have to accept notice.
Rule 11 we'll keep next week. And we will hear you give a copy of the petition to the other side. And we can at least hear you at that stage on the order 7 rule 11. So order 7 rule 11, you need not address us right now.
Yes, no, look, we are also seeking, we are also seeking in the order 7 rule 11. We were also seeking stay of proceeding before the trial court.
All right.
But
that give a copy to Ms. Diwan and Mr. Solicitor. And
given a copy.
Yeah,
sir.
no difficulty. We will hear that.
We'll give. There's no
that we'll hear separately. We'll list it
because
next
there's
week and take it up.
another issue, because earlier the interim order that your lordships that is operating is with regard to namaz, etc. But now, Malaz, perhaps it may be now appropriate, because what is happening is, and our past experience has shown us, that applications are moved, Malaz, before the trial court. In this particular case, the order was passed on Friday evening. It was very difficult for us to even take recourse to a remedy. Even this order, Malaz, when the matter was heard by the learned Chief Justice, the order was passed today. We made an application before the learned Chief Justice that gave us some breathing time to approach the Supreme Court. Even that time was not given to us. Therefore, that was not given. We specifically asked for stay. Thereafter, Malaz, there was a letter from the ASI that we proposed to come tomorrow early morning for the purposes of survey. That was brought to your lordship's notice, I think, Malaz, in the evening. And then thereafter, they did come in the morning at 7:30, despite it being brought to their notice that the matter was on your lordship's list and the matter would be taken up in the course of the hearing today. So this is, Malaz, the rip-roaring speed at which they are operating, which gives rise to, Malaz, a certain amount of apprehension of overreach. And that is legitimate. Now, the second aspect that I wish to point out is, so far as the issue of the Places of Worship Act, would your lordship give me a little more time, Malaz, to be able to fully state that point? Because, Malaz, that impinges on the survey. I wanted to read your lordship's judgment.
Mr. Ahmadi, we are not going to conclude the issue of the Places of Worship Act right now, because on an interlocutory order, on a procedural order for the appointment of a survey to decide the issue as to the applicability of the Places of Worship Act today, we are really deciding the entirety of the suit, if you are right on that.
No, I'm saying something else.
On an order for the appointment of a survey.
Malaz, may I make a submission? I'm not, Malaz, right now, for the purposes of a survey, if I can demonstrate to your lordship that given the provisions and the intent of the Places of Worship Act.
Mr. Ahmadi will not go into it right now, because conventional wisdom is that you never, when you have a procedural order or an interlocutory order, you never go into an issue which will go to the root of the suit. That has to be dealt with separately at the appropriate stage.
If I can just read the statement of objects and reasons only to make good this one point, that the very factum of having a survey and the intent to reopen old wounds.
So as a statement of object?
Yes.
So as a statement of objects?
Would your lordship see your lordship's judgment? It is reproduced. Great detail. Your lordship has, Malaz, page 247 of the report. Yes. Would your lordship see the judgment?
We'll have the act here. We have the act here. Just look at the screen. We've got the act here.
Yes. An act to prohibit, your lordship would have. In fact, Malaz, the objects and reasons are extracted in the judgment.
All right.
May I read that?
Let's see the objects and reasons for judgment.
Your lordship is the 711 judgment, the statement of objects and reasons, Malaz.
711 judgment.
The 711 judgment. Your lordship has it from that page.
1 second.
Statement of objects and reasons.
See page 39.
Page 39.
Yes.
Kara?
Just from the beginning, Manoj, in view
Yes,
of the
yes.
controversies, your lordship has it at the top.
75.
In view of the controversies arising from time to time
Yes.
with regard to conversions of places of worship, it is felt that such conversions should be prohibited. 2. In order to foreclose any controversy in respect of any place of worship that existed on the 15th day of August 1947, it is considered necessary to provide for the maintenance of the religious character of such place of worship as it existed on the 15th day of August 1947. As a consequence thereof, all the suits or other proceedings pending as on the 11th day of July 1991 with respect to any of such places of worship may abate, and also further suits or other proceedings may be barred. However, since the case relating to the place commonly called Ram Janmabhoomi Babri Masjid forms a class by itself, it has become necessary to exempt it entirely from the operation of this Act. Moreover, in order to maintain communal harmony and peace, matters decided by courts, tribunals, or other authorities, or those settled by the parties amongst themselves, or through acquiescence between the 15th day of August 1947 and the 11th day of July 1991, are also exempted from the operation of this Act. The 11th day of July 1991 is proposed as the commencement date of the Act, as on the day the President addressed the Parliament by making such a declaration. The bill seeks to achieve the above objectives. An act to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947 and for matters connected therewith or incidental thereto. Now, Malaj, before I come to section 3, section 2, the definition of the word conversion. Your Lordship will take it as extremely expansive. May I read that, Manoj? Please see, Malaj, section 2.
Yes.
2B. Conversion, with its grammatical variations, includes alteration or change of whatsoever nature. Now, your Lordships interpret
The whole list is on religious character, as Mr. Devan said.
Not
What is, because 3 says, you're right.
Yeah.
2B uses the expression conversion in a very broad sense to include an alteration or change of whatsoever nature. We will have to say, it is hereby declared that the religious character of a place of worship existing on the 15th of August, so and so and so, shall continue to be the same as it existed on that day. There are 2 bars. 3 is the bar on converting any place of worship of any religious denomination or any section into a place of worship for a different section of the or religious denomination. And 4.1 says, it is hereby declared that the religious character of a place of worship, therefore the religious character shall not be changed. So the whole question is really on what is the religious character.
now. Please see how
As on 15th August 1947.
has been interpreted by your Lordship in your Lordship's judgment. This is Malaj 20.
That's a matter for decision, Mr. Ahmadi.
No, that's right. But the question therefore is no. There is one passage, Malaj, with regard to the wounds of the past, and your Lordship say that is the very substratum of the Places of Worship Act. Now, having a survey into those aspects will itself, my lords, frustrate the object of the Act. That's my
We'll
submission.
consider that, Mr. Ahmadi.
But, my
We'll
lords,
consider that.
therefore, till then, my lords, this survey has
All right,
not-
Mr. Ahmadi, we'll dictate a short order now.
My lords, this survey with the greatest, my lords, am I testing your Lordship? I mean,
No, not at all. You never do, Mr. Ahmadi. It's just that we have to get on with our board as well.
I was just making a
You
very,
never
very
do.
humble endeavor
Yes,
to be able to, my lords, persuade your Lordships to say
yes.
that this was the intent of Parliament. This was the intent of Parliament. This is something, my lords, which was in the form of a promise held out, my lords, to one community that your places of worship will not be touched. And today you have a situation, my lords, where virtually, my lords, then this is only reduced to a homily. If suits are filed across the country, just with an everman, saying that, look,
Therefore, we are keen to ensure that the place that the mosque should not be touched. There should be no excavation.
Well,
That's why we had made that clear.
the problem is
We had made that clear even when we heard the matter on the first day, when we sent it back to the Allahabad High Court, because we couldn't resolve it here. So we said, all right, let the Chief Justice decide, or whoever has to
the
decide in the
findings
Allahabad
of the
High Court.
survey, my lords, will have the effect of virtually, my lords, allowing the genie to escape from the bottle with the greatest respect. I say this with a sense of responsibility, my lords.
Why are you apprehensive? If it goes against them, they take the consequences of the survey.
No, not only that. Today, my lords, today the manner in which I don't think I need to respond. My respectful submission is only this one, that I'm making a legal submission. To everything else, my lords, I will not respond. My respectful submission is, my lords, that the survey should not have been ordered in the light, my lords, of the express dictate of the Places of Worship Act and the object, my lords, with which it was conceived as interpreted by your lordship. Now, if your lordships are of the view, because it doesn't end here, you will have now applications thereafter to say something was discovered here, please seal that particular area also. You will then have an application saying, allow me to perform puja at this particular thing. Then you will say, because it's all a mosque premises. Kindly see, my lords, how it will work on the ground. These are salami tactics, my lords. Piece by piece, my lords, you're trying to edge me out from my property. That's my worry. And there is today no order of status quo. So every time, my lords, an application is made before the trial court, suppose tomorrow an application is made, saying that over here I found a deity, allow me to do my worship. You're encroaching into my area. Piece by piece, my lords, I'll be deprived of my property. That's my apprehension.
An order was passed by the District Judge Varanasi in original suit 18 of 2022, into bracket 693/2021, on 21 July 2023, by which applications 327C and 330C of the plaintiffs were allowed. Full stop. By those applications, while allowing the applications, the trial judge, the district judge, directed the Archaeological Society of India, into brackets ASI, to undertake a scientific, to invert commas, undertake the scientific investigation, stroke survey, stroke excavation on the property bearing settlement plot number 9130, excluding certain areas which were sealed by the orders of this court dated 17 May 2022, 20 May 2022, and 11 November 2022. Let's stop. Yes.
Fine. Lord Justice Partivaran. The entire proceedings or whatever, with your lordship said report will be kept in a sealed cover, but the entire proceedings also may be sealed, because if it is leaked, my lords, it has the propensity of some mischief.
What do you have to say? No, read me that. District judge, while allowing the application, issued the following directions. Colon, ये पेज 1 को A से लेकर पेज 3 तक कॉपी करना है, जो कोटेशन में है. District judge was assailed before the High Court of Judicature at Allahabad in proceedings under Article 227 of the Constitution. Next stop. By judgment dated 3 August 2023, the order of the district judge has been affirmed subject to the bracket 1, the observations made by the High Court in the text of its judgment, semicolon, and bracket 2, the contents of an affidavit which was filed by the ASI before the High Court. Let's stop. During the course of the hearing before the High Court, the Additional Director General, the ASI, was called upon to assist it, and in pursuance of the direction of the High Court, the Additional Director General ASI filed an affidavit setting out the nature of the proposed survey that would be carried out. Paragraph 16, 17, and 18 of the affidavit paragraph 16 to 20 copy करने हम लोग. Paragraph 16 to 20 of the affidavit filed by the ASI.
13 to 20.
Paragraphs 13 to 20 of the affidavit filed by the ASI are extracted below for convenience of reference. Full stop. Apart from the affidavit, the deponent, Sri Alok Tripathi, who is the Additional Director General of the ASI, assisted the court in person, appeared before the court in person. Full stop. The submissions which were made by the ADG have been recorded in the following extract of the judgment of the High Court. Colon. Into invert commas, page 11 में last 3 lines, 3 dots. He submitted से शुरू कर लो. Up to the end of the paragraph. The High Court has held that the order of the district judge directing a survey falls within the ambit of Order 26, Rule 10A of the CPC, Code of Civil Procedure 1908. Hence, where a question arising in a suit involves any scientific investigation which cannot, in the opinion of the court, be conveniently conducted before the court, it may, if it thinks necessary or expedient in the interest of justice, so to do, issue a commission for that purpose. In paragraph 21 of its judgment, the High Court has clarified, the High Court has dealt with the apprehension that the survey would envisage an act of excavation or destruction of the structure existing at the site. Full stop. The High Court has recorded the statement of the Additional Director General, ASI, as well as of the Additional Solicitor General who was appearing for the Union of India, that no excavation whatsoever will take place. Full stop. Before we deal with the full stop. It was in this backdrop that the High Court observed that since the Department of Archaeology and the council representing the department had expressly stated that no damage would be caused to the property in question, the survey which was proposed may be permitted to be carried out. Full stop. It is in this backdrop that in the concluding paragraph of its order, the High Court clarified that while it was affirming the order dated 21 July 2023 of the district judge, this was subject to the observations of the High Court and the content of the affidavit which was filed on behalf of ASI. Full stop. Before we deal with the submissions which had been urged on behalf of the appellants by Mr. H.A. Ahmadi, Learned Senior Counsel, it needs to be clarified at the outset that it has been clarified on behalf of ASI by Mr. Tushar Mehta, Learned Solicitor General, that as a matter of fact, the entire survey which was envisaged to be carried out in pursuance of the order of the district judge would be completed without any excavation at the site and without causing any destruction to the structure. Full stop. Next. On behalf of the petitioners, it has been submitted by Mr. H.A. Ahmadi, Learned Senior Counsel, that bracket 1, the act of conducting the survey, the act of conducting the survey, the conducting of a survey is contrary to the provisions of the Places of Worship into brackets Special Provisions bracket Act 1991 and the genesis of which has been explained in the judgment of the Constitution Bench in so-and-so versus so-and-so 2021 SCC page 1. Semicolon, bracket 2. In the suit of 1991, in pursuance of an identical prayer, a survey by the ASI was ordered, which, however, has been stayed by the High Court by an order dated 9 September 2021. 3. A similar issue pertaining to an order for carbon dating of a structure which is claimed to be a shivling by the plaintiffs and a fountain by the defendants is pending in SLP 11351 of 2023. And in the course of the proceedings before this court, the order for the survey was stayed on the Solicitor General joining in the submission that the process of carbon dating may be of an invasive nature, semicolon, bracket, may partake of an invasive nature, semicolon, bracket 4, an order of status quo in respect of the property was passed in the judgment of this court in 1994 to SEC 48 because of a threat to the property. And bracket 5, while an order for conducting a scientific investigation or survey under Order 26 Rule 9 may be passed at any stage, ordinarily, a scientific survey ought not to be ordered until the court is cognizant of the issues that could arise in the suit. Let's stop. On these premises, it has been urged by learned senior counsel that the order for a survey needs to be interfered with at this stage. Let's stop. On the other hand, Ms. Madhvi Diwan, learned senior counsel, appearing on behalf of the original plaintiffs in the suit, submitted that bracket 1, an order under Order 26 essentially is for the benefit of the court, which requires such a survey to be conducted to assist it in deciding the substance of the controversy in a suit. Semicolon, bracket 2, the order of the trial judge ordering a survey is neither adversarial nor prejudicial, since it is not determinative of the substantive rights of the parties. Semicolon, bracket 3, all parties would be entitled to file their objections to the report of the ASI and to seek cross-examination should the survey be let into substantive evidence. 4, the submission which has been based on the provisions of the Places of Worship bracket Special Provisions bracket Act 1991 really begs the question, because the issue in terms of the provisions of Section 3 of Section 4 bracket 1 is as regards the religious character of the place. Full stop. Paragraphs, the frame of the plaint would indicate that the very contention of the plaintiffs is that both before and after 1947, the religious character of the place is indicated by acts of continuing worship. 4, the job of the function of the ASI is to preserve and protect property, preserve and protect monuments of historical importance, and hence there is no basis for the apprehension that any damage would be caused to the structure. And 5, the circumstances pertaining to the earlier suit of 1991 are distinct inasmuch as in that case the suit was one on title and an application under Order 7 Rule 11 CPC was allowed by the trial judge. The order of the trial judge was set aside in first appeal, against which proceedings under Article 227 were instituted by the original defendant before the High Court, in which there was a stay of the proceedings in the suit. in this backdrop, comma, when the trial judge allowed an application for a survey by the ASI, comma, this order was stayed by the High Court during the pendency of the proceedings. Let's stop. Next. The order of the learned trial judge under Order 26 Rule 26 Rule 10A cannot prima facie at this stage be construed to be without jurisdiction. Let's stop. Order 26 Rule 10A actually Order 26 Rule 9 है ये 10A कहाँ से आ गया है? Stipulates that where any question arising in a suit involves any scientific investigation which cannot, in the opinion of the court, be conveniently conducted before the court, comma, the court may, if it thinks it necessary or expedient in the interest of justice so to do, issue a commission to such person as it thinks fit, directing them to inquire into such question and report thereon to the court. Under Rule 2 of Rule 10A, comma, the provisions of Rule 10 of the order shall, as far as may be, apply in relation to a commissioner appointed under the rule, as they apply in relation to a commissioner appointed under Rule 9. Let's stop. Rules 9 and 10 of Order 26 therefore assume relevance and are extracted below. थोड़ा सा Rule 9 पे जाओ या थोड़ा ऊपर कर लो. In terms of Rule 10, or in terms of Order 26, Rule 10, the commissioner has to submit a report in writing to the court. Let's stop. The report of the commissioner and the evidence taken by him constitute evidence in the suit and form part of the record. Let's stop. However, the court, and with its permission, any of the parties may examine the commissioner personally in open court, touching any of the matters referred to him or mentioned in the report, or as regards the report, including the manner in which the investigation has been made. Let's stop. The court is also empowered, if it is dissatisfied with the proceedings of the commissioner, to direct such further inquiry to be made as it shall think fit. Let's stop. The evidentiary value of any report of a commissioner is therefore is a matter to be tested in the suit and is open to objections, including cross-examination. Full stop. Hence, a report of the commissioner does not by and of itself amount to a substantive finding on matters in dispute and is subject to the processes of the court during the course of the trial. Full stop. At this stage, comma, the court cannot, the court, while acting as a trial judge in the suit, has exercised discretion under Order 26 Rule 10A to direct a scientific investigation by the ASI. Good stop. While the High Court has found no reason to interfere, the High Court has found no reason to interfere, having set out the legal position which constrains the nature of the challenge under Article 227 of the Constitution while dealing with an interlocutory order of this nature. At the same time, the High Court has introduced certain safeguards which need to be reiterated in the course of the present judgment of this court. Full stop. Having regard to the nature and ambit of a court-appointed commissioner, we are unable to differ with the view of the High Court, particularly while exercising the jurisdiction under Article 136 of the Constitution. Full stop. The limitations which operate on the High Court while exercising its jurisdiction under Article 227 must a fortiori govern a proceeding when this court is considering a petition under Article 136 against an order of the High Court in such a proceeding. Be that as it may, the High Court was, in our view, correct in introducing certain specific directions to circumscribe the nature of the order which was passed by the district judge. Full stop. Reading the directions which have been issued by the district judge, it is apparent that they would be amenable to the carrying out of an excavation at the site. Full stop. However, during the course of the proceedings before the High Court, ASI has clarified on affidavit that it was neither carrying out any excavation nor would the survey involve any destruction of the property. Full stop. While recording the submission of the Solicitor General, as we have in the earlier part of this order, to the effect that the survey shall not involve any excavation at the site or any destruction of the structure, we also order and direct that the entire process shall be concluded through any non-invasive methodology that may be adopted by the ASI. Full stop. We reiterate the direction of the High Court that there shall be no excavation at the site, which was in accord with the statement which was made before the High Court by the ASG and which has been reiterated in the submissions made by the Solicitor General before this court on behalf of ASI. Full stop. The report which will be prepared by the ASI shall, in terms of the provisions of Order 26, be remitted to the trial court and shall thereafter abide by the directions which would be passed by the trial court, by the district judge at the trial of the suit. Full stop. The district judge shall, in accord with the provisions of, in accordance with the trial of the suit. That's all I think we have to.
What is Archaeological Society of India?
Survey.
Second, madam, instead of saying, this is my request, that will not use any invasive methods. We'll do everything as per the affidavit, because what will invasive would be a little matter of construct.
Invasive, no, we'll say non-invasive. Let it be. Both my brothers also felt, that let it be non-invasive.
Wrongly construed that.
In fact, actually, why? I'll tell you why. Because in one place, the High Court has used the word invasive method. I think that's an error by the High Court. They wanted to use the word non-invasive. But while reading it this morning and again in the court right now, I found that they have used the word invasive. So that's why that clarification was necessary. It's obvious that the High Court wanted to say non-invasive, but that was just a printer's devil, that's all.
Otherwise, but the apprehension was that something can come and say, no, this is invasive. So it becomes a matter of interpretation by the parties. But I limited it. We have said what we are going to do in the
Okay. The petition is disposed of. Now order 7, rule 11, you can take a date, whatever you both want, so that we can hear you.
We are only non-miscellaneous then, because
NM,
it will take a little bit of.
that'll take a little time. Even this took half an hour, 45 minutes.
Just-
We'll keep that on
just
a
one request, ma'am.
NMD mein rakho.
What as your lordships had suggested, and just as part, it had fallen from my lord knows, that let it be kept in a sealed cover. That is,
It would be.
because
Seal cover, you know.
because it may abide by the 711, Malaj, ultimately.
Your lordships have said the evidentiary value would be decided subsequently.
No, that's all right. But
That's
Malaj, what my submission is, that let it be kept in a sealed cover. Your lordship decides my order 7 rule 11 against me, then of course, Malaj, then that's a very reasonable thing, Malaj.
In our mind,
Yes.
but what has been fallen from my lord, the Chief Justice, it should protect the interest of both the sides.
Malaj, I'm sanguine in that hope. I'm sanguine in that hope. But Malaj, history has taught us something else. I mean, history has taught us something else, Manoj, on 6th of December.
That we'll close it, Mr.
That's
Hari, thank you.
That's.
Therefore,
What is item 7 now?
therefore, Manoj, there's also a reason, Manoj, why there is some amount of suspicion and there is lack of trust at each and every stage.
All right, Mr. Hari, yes.
I'm extremely grateful.
Item,
Manoj, just one thing, Manoj,
yes,
your lordships have earlier said, Manoj, that namaz, etc., everything should.
this has nothing to do with
Your
that.
lordship
Yeah.
makes it
Of
clear
course,
there.
that order is not until today. Those orders continue.
That was recorded in another petition.
That order is not tagged with this proceeding or until today. That order continues, undoubtedly.
It was in 9388.
Yes.
That order is not until today.
In past over item 7, need not
Sir.
delay your option. The other side's appeal. It is astonishing why it is filed. There is a direct judgment. We have a chart. Para to para, Noida lease, Justice Joseph's bench was authored by him, held that it's an operational creditor. They've still filed an appeal. Just take this chart, please. Take this chart. It's the identical matter, right? The office report got dismissed two SLPs.
Yeah, we should have grabbed it. Yeah.
My lord.
Argue.
ऑफिस रिपोर्ट में नहीं लिखा है ऑफिस रिपोर्ट में लिखा है क्या 3 civil appeals have been dismissed Manas by your lordships.
What is it?
3 other ones.
Can you share a copy what you're giving?
Ravindra Kumar.
Give a copy to them. You're right.
Ravindra Kumar.
It is not covered, nothing to do with this, my lord. I demonstrate it here and now.
Dr. Singhvi.
Different.
Dr. Singhvi, we are at 2 minutes to 4 o'clock at TGIF. So, I mean, thanks.
There I can't.
We'll keep it on another day now.
So there is some urgency.
Okay, रखो Monday को रखो. Monday को रखें.
Not Monday, they will have it Friday. I have difficulty on Monday, but there is a order.
Some petition, my lord.
We'll accommodate you on Monday. Come by.
Monday afternoon, your lordship is release coming in parliament, and I'm the beach keeper. I know I won't be here in the afternoon. Your lordship either will happen on Tuesday.
They want
Friday, I'm saying.
contempt with their move.
What will happen?
They will never disclose.
But Dr. Singhvi, I don't believe that your whole of Monday is in service of the nation. Your first half, you're not going to serve. First half, we'll finish it off.
Very well. Then I'll come on Monday. I'll be here for first half.
First half.
Nothing to do.
But if it doesn't reach in the first half, then we'll accommodate Dr. Singhvi.
They will not press the contempt if they move. And every day they are insisting.
Then you keep it on Friday, he'll not press his contempt.
The statement they will not say.
But Dr. Singhvi said 4 days they're not going to press the contempt. Keep it on Friday then.
The date is 23rd August. There's no question.
There's no difficulty. We'll keep it on Friday then.
Friday.
Rising out of that.
No problem. They've clarified. They'll not push you on the contempt.
Very well.
Item 9. Third time it is adjourned. It's only amendment.
Hey, what is this? This is Pratap, this is only an amendment. I mean, now forget it.
The amendment they have come.
And now we'll dismiss it. What is that? They allowed the amendment. See, there's nothing. If his challenge may lack substance.
Please kindly keep the amendment aside for just so that I can just make this submission.
Yes.
Kindly see page 104. See, what is the issue here? Kindly
Formulate it now. Don't go
Okay,
with
very well,
pages.
my lord.
Yes.
104 will show that, my lord, I have an existing factory
You want to
Yeah.
expand.
No, kindly hear me for 2 minutes.
So that's what we are doing, but we also talk when we are hearing, that's all.
My lord, on the right side, that's in the middle is this property where we want to expand. On the other side, my lord, is the factory of is another factory. So we are in industrial land. What happened is under the Goa industrial Goa investment promotion.
What has allowed
No,
him?
No, I am not on the amendment. Kindly see the injustice because your lordship is in 136. I am trying to show the injustice
All
that
right,
has happened.
right. So what is this?
I am not on the amendment, my lord. Please keep that
So
aside.
that's the only thing we just
No, my
sorted
lord.
out.
I moved an application for permission to urge additional grounds. Please hear me.
No,
only
but
on
what
that.
is the order? Order is only allowing an amendment,
Order,
right?
Rising out of the order, I will not go out of the order, my lord.
So what is the submission?
Yes, the submission is this, my lord. I obtained that clearance under the Act after
Right.
3 years.
Right.
Then a writ was filed in 2018. 2019, no orders were passed regarding status quo till 2019. 2019 status quo orders passed, and the court said, you now go and get an EC. Right, my lord? Then, my lord, I went through the EC process. It's an arduous process.
You got an
So,
EC.
I got the EC. The EC said, if anyone is agreed, you can challenge it. I waited for the 30 days, brought out the publication. Then, my lord, after the period for challenge was over, I moved the High Court for modification or variation of the order. My respectful submission is that application has not been considered. Kindly see. They say, oh, amendment has come. My lord, prima facie.
Relax, relax.
The EC prima
What has not been, one second,
Yes.
what has not been considered? Your application for?
for variation because pursuant to the court said you go and get an EC.
We'll
which is
direct the
assessed.
High Court to consider it.
No, my lord, but my lord, it must be taken up immediately and let it be conditional. My lord, the EC is prima facie. When I get an EC, prima facie, I have satisfied every requirement. Now, my learned friends, clients
Now,
make
it was-
allegations.
Mr. Parekh says in the last para they have
Yes,
said that.
but because the amendment was taken up, immediately the amendment is given priority. My lord, I can't be put like this, my lord. For 8 years, I have suffered an expansion. That's the point, my lord.
Mr. Venugopal, we
Lordship.
see that. You are
Yes,
appearing for an industry, you have invested money.
Yes,
Now tell us, they've said miscellaneous civil application 166 of 23 is posted for further consideration on 20th April.
my lordship will then say that will be heard on that date, my lord, not
Oh,
the
yes,
amendment.
yes, yes.
Because, my lord, they can, I'm not saying, they
Civil-
can also resist the amendment.
We are with you. We are with you. We'll pass that order. Let them consider your application.
Lordship may kindly direct that this may be taken up and.
While we are not inclined to interfere with the order of the High Court, allowing the application for amendment, the High Court has also directed that miscellaneous civil application number 166/2023/F is posted for further consideration on 20 April
That's
2023.
the application for modification, my lord, of the interim order.
This application, as the court is informed, is an application moved by the petitioner for modification of
The order of interim injunction, my lord,
Of it-
restraining me from. pursuing.
the order of interim injunction,
Yes.
restraining the petitioner from proceeding further.
Lordship.
Full stop.
This is the date.
Since
my lord,
the
is
application
11/9/2019, my lord. That's the order.
Since the order, since the
Now, my lord, is saying
Since the application for modification of the order dated 11 September 2019,
19, my lord.
it's still pending consideration before the High Court, we request to the High Court to take it up with all reasonable expedition and to endeavor a disposal of the application within a period of 1 month from the date on which a certified copy of this order is placed on its record.
I'm deeply obliged.
Subject to the aforesaid, the petition is disposed of.
Obliged, me.
Please, your lordship.
May be permitted to mention, my lord.
Please, your lordship.
No? 11.
Yes. My lord, this is a civil appeal, my lords, filed against the order of the NCLAT. The whole issue is this. This is a completely different form of transaction. It's not a simple bill discounting. There's a platform known as CredX. My lords, what we do is, all financiers, my lords, put money into that, contribute. CredX then calls people like buyers who want, my lords, to be able to sell the goods and get the money. And these
They say that there was no direct disbursal by
that is
you
where
to the
I'm saying it's
cooperative
wrong. That's where
debtor.
they've taken the traditional form of bill discounting, seller But that is not the
And you
transaction.
stepped into the shoes of the operational.
That is where it
creditor.
is wrong, because this is it's a new system done for the first time, which needs to be looked into in its own merits, not as though it's the other system. Please see page I. This describes how it works, Manoj. Page I.
You have an alternative remedy.
And the
They have, my lords.
9, right?
Yes.
Court has left it open to you to invoke proceedings under section 9.
My lords, then my status, they have said, is an operational creditor. Please, being a,
Right.
it's vital. It goes to the root of the matter. Please see page I.
How do you say that you're a financial creditor?
I'm answering, my lord. Please just see page I. This describes, my lords, in a very short way, how this transaction works.
Yes.
I'm actually a financer. I am not a bill discounter. Please see, my lords, I'm defined as a financer by the agreement with the person, with the corporate debtor. The agreement with him, I'm described as a financer. The petitioner financial creditors, my lords, has page I.
But the fact remains, whatever you call yourself, you are still.
No, the
basically
transaction.
You are a
But
discounter.
this is not a typical transaction of bill discounting with a bill. This is a platform which is raised, my lords, which is on through, my lords, the web system. You have a platform. People in the platform, there, my lords, have invested as financiers, not for any particular transaction. They contribute. People who want finance approach this CredX, which is the platform, and say, we require finance for something. Then these financiers' amount is given to them, and that bill at best is nothing but a security. It is a security for a loan. The actual transaction is a loan I give the buyer to be able to sell his goods. And the security I get is the bill. All I'm requesting, this is not a case where we require any order from my lords or any interim order or anything, but it's something which needs to be looked into. How do these, because this has now become a new. In fact, NCLT Bombay had given a different decision.
Sir, Sundaram, what we'll do is this, that one way or the other, I mean, let's have the assistance of the other side also. We'll issue notice.
Please, madam.
And we'll hear this matter. We'll
Please, Your
serve them Dasti and come in 3 weeks or so. 4 weeks we can keep it.
My lords, please.
You may be possibly right. I mean, we've put you what the findings are, but let's have we'll hear the other side also. It's an interesting point.
I'm very grateful. Lordship.
Notice issue.
Lordship. Lordship.
31.
Where is
Online. So NMC Council, Mr. Gaurav Sharma is online. He's
Mr. Sharma?
Yes, my lords.
Can you come before the court on the next day? We want some assistance. You know, if a student withdraws from a seat
Yes, my
after
lord.
the last date, the seat goes vacant for the medical college.
Yes, my
What
lords.
do the MCI regulations say? How much can the college forfeit? What is the consequences? Are there any regulations by the MCI?
My lord, there's no regulation, but generally either they have to continue or they have to pay for the entire college, because most of them are the private colleges. They will lose the fees for the entire course. And these are the students of higher education. My lord, they know very well what are the pros and cons of all these things. I'm sorry, my lord, NMC was not a party here, so I was not aware of this matter, my lord.
Can you just come and assist us? Maybe we'll keep it next Friday.
Yes, my lord. My lord, include me, my lord. I'll be there, my lord. I'll file on Wakalatnama and so on.
copy. He'll serve copy.
Just have a copy and just see if there are any regulations. Then do the UGC regulations apply?
I'll find out, my lord. I'll find out.
Just find out, because there's a little bit of a grey area on this. Next Friday, Mr. Sharma, just come and assist the court.
Yes, my lord. Yes.
She humble request 31-3. She have to join 7th for the exam. Can we
Next Friday, we are keeping it now.
70th is the next.
That's okay. We'll keep it on Friday now. We can't.
Please, sir.
Yes, Mr.
This special bench, but what is happening? When your lordship is fixed it, which could not have a patch of matters, same issue, old order suddenly is coming on Monday before another court of another bench. Lord, it will only 1 minute. Please, waited for 2 years, 2 hours to mention. Please permit. Lord, Lord, a whole batch of matters, old matters are suddenly coming before another court on Monday.
Which matters are these?
Lord, this duty-free shops. Your lordship has now put a special bench today. After this is, Lord, unless time is fixed, Lord, it's not possible for this court to hear it. And Lord, contempts are pending, refunds are pending. Everywhere there is action. Another batch of matters are coming on Monday before another court.
Why didn't you mention before that court that you know?
With the date and timing, Lord, so that it will not take some time because it's
Alright.
very,
Next
but
Tuesday,
more
we are
than
in the midst
1,000
of
crores of
the-
refund is now the
Even
exposure.
next Tuesday,
More
we are in the
importantly,
midst of
limitation.
the, Article 370, Constitution bench is sitting. So we can maybe sit on, we can take it up on
Friday, ma'am.
next Friday.
Some time may be fixed.
We'll take it up at 2 o'clock on Friday. So we'll have a little time.
Extremely obliged.
Fully one.
Deeply obliged.
Or part of the 34.
This may also be taken up on Friday, Millard. We would like to argue.
Almost it was getting over.
No, our side, we have not yet completed. We would like to have is about
Bench rakho, hum teen.
Monday.
But this combination is not available.
We'll try and switch we'll be in the same combination on Monday.
Can it be the,
29 matters so far.
no, can it be the,
But that 29 looks short, but those 29 are all sensitive, heavy commercial matter.
Can
You know how it is today also. Look at the way
can
the
it
board
be the
ran.
first of after notice
And
matter?
then about 8 or 9 supplementaries come in the night.
absolutely.
After the fresh matters, if it can be done.
Yeah, we'll take it immediately after the flight.
After the fresh
Yes.
matters. Very well.
You know, it's just that we didn't, because so many matters across the country are dependent. We don't want to just sort of, if it was a usual civil appeal, we would have concluded, say, file written submission.
Right.
Just 5 minutes, they will also have the satisfaction of addressing us. You were addressing us on this, that basically survivorship has gone now in section 6. And survivorship is really replaced by succession. So, but even so, you'll have to, even assuming that is so, will the child born from a void marriage or voidable marriage have a share in respect of the property of the father prior to partition? The copas,
There is an
But I have found something very, very interesting on that. With the Law Commission report before this, not 2005, I've sent it to your lordships today morning.
Yes.
Kindly have a look in case when your lordship finds time, my lord. There is a serious difference between 6 and 8. How the Law Commission wanted that co-personality to be kept alive. Otherwise, 6 could have been gone. Only 8 could have remained. Class 1 could have remained. The interstate succession.
Can take 2 minutes to explain that to us.
Yes, ma'am.
My lord,
I'll send it to your lordship.
it's not no longer limited only to a male. Now, my lord, after the 2005 amendment.
A woman also.
Woman also, my lord. So a scenario where the woman's second marriage is considered to be unlawful. Children born from that union will also stand disentitled. If your lordship will examine the scheme, and that is what I wish to submit before your lordship, when your lordship will examine the scheme of the Hindu Succession Act,
I'll let you do this.
Which is heirs.
On Monday, just show us those 2-3 provisions, make your submissions in 10 minutes. Just go to the heart of the matter.
I'll straight away come to the provision only.
Yeah.
There are 2 judgments, my lord, which really don't discuss the analysis, my lord, in terms of how, my lord, your lordships have been looking at the act. But there are 2 judgments, one by Justice Venkatramaiah and one by Justice Sinha, where, my lord, children who have now been found to be illegitimate have been given a share in co-partnership property. In Justice Sinha's judgment, the child has not been determined to be a co-partner, but entitled as an heir.
And Justice Venkatramaiah's judgment?
Justice Venkatramaiah's judgment only says that illegitimate children are also entitled to a share in ancestral property, but does not go on to examine whether a co-partner or only as class 1 legal heir on the line of Justice Ganguly's judgment. And when your lordships will, I'm sorry.
We have,
Lordships, I have.
And when your lordships will.
Lordships, I have submitted a note.
Even when.
I have tried to clarify the question with Lordships agreed. Question will notice been submitted.
All right.
No, I also. I have.
Right.
We'll
come back on Monday. We'll come back on Monday now.
Very well.
Monday?
Yes.
लॉ स्ट्रीट भारत राष्ट्र के हित में।